Involving Philippine Constitution. First case Sanidad versus Comelec. Issue: whether Section 19 of Comelec Resolution No. 2167 is constitutional or not. Facts of the case. Comelec Resolution No. 2167 was promulgated due to the enacted RA No. 6766, an act providing for an organic act for the Cordillera Autonomous Region, last October 23, 1989, which paid for a call of a plebiscite for its ratification. Original schedule was reset from December 27, 1989 to January 30, 1990. Facts. Comelec Resolution No. 2167 was promulgated due to the enacted RA No. 6766, an act providing for an organic act for the Cordillera Autonomous Region, last October 23, 1989, which paid for a call of a plebiscite for its ratification. Original schedule was reset from December 27, 1989 to January 30, 1990. Allegations of Sanidad. Unconstitutional as it violates the constitutional guarantees of the freedom of expression and of the press. Constitutes a prior restraint on his constitutionally guaranteed freedom of the press, because of its penal provisions in case of violation. Responses of Comelec. Not violative of the constitutional guarantees of the freedom of expression and of the press, but only a valid implementation of the power of the Comelec to supervise and regulate media during election or plebiscite periods as enunciated in Article 9c, Section 4 of the 1987 Constitution and Section 11 of RA 6646. Does not absolutely bar petitioner from expressing his views and or from campaigning for or against the Organic Act. He may still express his views or campaign for or against the Act through the Comelec space and airtime, magazine or periodical in the province. Facts. This is a petition for certiorari assailing the constitutionality of Section 19 of Comelec Resolution No. 2167 on the ground that it violates the constitutional guarantees of the freedom of expression and of the press. On October 23, 1989, Republic Act No. 6766, entitled An Act Providing for an Organic Act for the Cordillera Autonomous Region, was enacted into law. Pursuant to said law, the city of Baguio and the Cordilleras, which consist of the provinces of Benguet, Mountain Province, Ifugao, Abra and Kalinga-Apayao, all comprising the Cordillera Autonomous Region, shall take part in a plebiscite for the ratification of said Organic Act originally scheduled last December 27, 1989. Held. Petition is granted. Section 19 of Comelec Resolution No. 2167 is declared null and void and unconstitutional. TRO made permanent due to the following reasons. 1. It has no statutory basis. 2. Form of regulation is tantamount to a restriction of petitioner's freedom of expression for no justifiable reason. 3. Affected by the issues presented in a plebiscite should not be unduly burdened by restrictions on the forum where the right to expression may be exercised. Second case. Lambino versus Comelec. Issue: whether or not the initiative petition of Lambino Group for the amendments of the Constitution complied with the Section 2, Article 17 of the Constitution. Facts. Lambino Group gathered signatures for an initiative petition to change the 1987 Constitution. On August 2006, they filed a petition with the Comelec to hold a plebiscite that will ratify their initiative petition anchored by RE 6735, or the Initiative and Referendum Act. It mainly targets Article 6 and 7 of the Constitution that will transform our government from bicameral presidential system to unicameral parliamentary form. The Lambino Group alleged that their petition had the support of 6.3 million individuals that constitute 12% of all registered voters, with each legislative district represented by at least 3% of its registered voters by signing in the signature sheets. The Comelec denied due course of the petition due to lack of enabling law that governs their initiative petition and invoked the court's ruling in Santiago v. Comelec case declaring that RA 6735 is inadequate to implement the initiative clause on proposals to amend the Constitution. After receiving the parties' memoranda, the court considered the case submitted for resolution. Held. There is not a single word, phrase, or sentence of the text of the Lambino Group's proposed changes is attached to it. The signature sheet does not show to the people the draft of the proposed changes, hence, they merely ask question whether the people is favorable to the shift of the government's form. Section 2, Article 17 of the Constitution does not expressly state that the petition must set forth the full text of the proposed amendments. However, the deliberations of the framers of our Constitution explicitly revealed that they intended that the people must first see the full text of the proposed changes before they sign, and that the people must sign on a petition containing such full text. The court also declared that the petition violates Section 2, Article 17 of the Constitution merely because the petition is not an amendment, but a revision. Revision broadly implies a change that alters basic principle in the Constitution, like altering the separation of powers or the system of checks and balances. It is also a revision if the change alters the substantial entirety of the Constitution, when the change affects substantial provisions of the Constitution. Third case. Javalana v. Executive Secretary. Facts. Petitioner filed a case to the Supreme Court to restrain respondents from implementing any of the provisions of the proposed Constitution not found in the present Constitution, referring to that of 1935. Javalana alleged that the President is without authority and jurisdiction in implementing the said proposed Constitution and that the election held was not a free election, hence, null and void. Issue: whether the Constitution proposed by the 1971 Constitutional Convention has been ratified validly. Ruling: Justices Macalintal, Zaldivar, Castro, Fernando, Tejenki, and Concepcion, or 6 members of the court also held that the Constitution proposed by the 1971 Constitutional Convention was not validly ratified in accordance with Article 15, Section 1 of the 1935 Constitution, which provides only one way for ratification, i.e., in an election or plebiscite held in accordance with law and participated in only by qualified and duly registered voters. However, it is conceded that the doctrine stated in some American decisions that a new constitution once accepted acquired by the people must be accorded recognition by the court. Fourth case. Imbong v. Comelec. Facts. Manuel Imbong and Raul Gonzalez, filing separate cases and both interested in running as candidates for delegates to the Constitutional Convention, question the constitutionality of RA number 6132, claiming that it prejudices their rights as such candidates. On March 16, 1967, the Congress, acting as a constituent assembly, passed Res. No. 2, which called for a constitutional convention which shall have 2 delegates from each representative district. On June 17, 1969, the Congress passed Resolution No. 4 amending Resolution No. 2 by providing that the convention shall be composed of 320 delegates with at least 2 delegates from each representative district. On August 24, 1970, the Congress, acting as a legislative body, enacted RA 6132, implementing Residential Nos. 2 and 4 and expressly repealing Art. A 4914 which previously implemented Res. No. 2. Gonzalez assails the validity of Sections 2, 4, 5, and PR 1 of 8A, and the entire law, while Imbong questions the constitutionality of PR 1 of Sector 8A of said Art 6132. Issues. 1. Does the Congress have the right to call for a constitutional convention and set the parameters of such convention? 2. Are the provisions of RA 6132 constitutional? Held. 1. The Congress has authority to call a constitutional convention as the Constituent Assembly. The Congress also has the authority to enact implementing details, contained in Res. Numbers 2 and 4 and RA 6132, since such details are within the competence of the Congress in the exercise of its legislative power. 2. The provisions are constitutional. Sector 4 of RA 6132 is merely an application with Sector 2 of Art. 12 of the Constitution and does not constitute a denial of due process or equal protection of the law. Sector 2 also merely obeyed the intent of the Congress in Res. Numbers 2 and 4 regarding the apportionment of delegates. The challenged disqualification of an elected delegate from running for any public office in Sector 5 is a valid limitation as it is reasonable and not arbitrary. Lastly, PR 1 of Sector 8A, which is both contested by the petitioners, is still valid as the restriction contained in the section is so narrow that basic constitutional rights remain substantially intact and inviolate, thus the limitation is a valid infringement of the constitutional guarantees invoked by the petitioners. Fifth case. Miriam Defensor-Santiago v. Comelec, GR number 127325, March 19, 1997. Facts. Delphin alleged in his petition that he and the members of the movement and other volunteers intend to exercise the power to directly propose amendments to the Constitution granted under Section 2, Article 17 of the Constitution. Attached to the petition is a copy of a petition for initiative on the 1987 Constitution embodying the proposed amendments, which consist in the deletion from the aforesaid sections of the provisions concerning term limits, and with the following proposition. Do you approve of lifting the term limits of all elected government officials, amending for the purpose Sections 4 and 7 of Article 6, Section 4 of Article 7, and Section 8 of Article X of the 1987 Philippine Constitution? According to Delphin, the said petition for initiative will first be submitted to the people, and after it is signed by at least 12% of the total number of registered voters in the country, it will be formally filed with the Comelec. On December 18, 1996, The petitioners herein Senator Miriam Defensor-Santiago, Alexander Padilla, and Maria Isabel Onpin filed this special civil action for prohibition, raising the following arguments. 1. The constitutional provision on people's initiative to amend the Constitution can only be implemented by law to be passed by Congress. No such law has been passed. 2. It is true that RA number 6735 provides for 3 systems of initiative, namely, initiative on the Constitution, on statutes, and on local legislation. However, it failed to provide any subtitle on initiative on the Constitution, unlike in the other modes of initiative, which are specifically provided for in Subtitle 2 and Subtitle 3. This deliberate omission indicates that the matter of people's initiative to amend the Constitution was left to some future law. 5. The people's initiative is limited to amendments to the Constitution, not to revision thereof. Extending or lifting of term limits constitutes a revision and is, therefore, outside the power of the people's initiative. 6. Finally, Congress has not yet appropriated funds for people's initiative, neither the Comelec nor any other government department, agency, or office has realigned funds for the purpose. Issues. Issue number 1. Whether RA number 6735, entitled An Act Providing for a System of Initiative and Referendum and Appropriating Funds Therefore, was intended to include or cover initiative on amendments to the Constitution, and if so, whether the Act, as worded, adequately covers such initiative. Issue number 2. Whether that portion of Comelec Resolution number 2300, in Rules and Regulations governing the conduct of initiative on the Constitution, and initiative and referendum on national and local laws, regarding the conduct of initiative on amendments to the Constitution is valid considering the absence in the law of specific provisions on the conduct of such initiative. Issue number 3. Whether the lifting of term limits of elective national and local officials, as proposed in the draft petition for initiative on the 1987 Constitution, would constitute a revision of, or an amendment to, the Constitution. Ruling. Ruling on the first issue, RANO. 6735 intended to include the system of initiative on amendments to the Constitution but is unfortunately inadequate to cover that system. Section 2 of Article 17 of the Constitution provides, amendments to this Constitution may likewise be directly proposed by the people through initiative upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. No amendment under this section shall be authorized within 5 years following the ratification of this Constitution, nor oftener than once every 5 years thereafter. The Congress shall provide for the implementation of the exercise of this right. This provision is not self-executory. In his book, Joaquin Bernas, a member of the 1986 Constitutional Commission, stated without implementing legislation Section 2 cannot operate. Thus, although this mode of amending the Constitution is a mode of amendment which bypasses congressional action, in the last analysis it still is dependent on congressional action. Bluntly stated, the right of the people to directly propose amendments to the Constitution through the system of initiative would remain entombed in the cold niche of the Constitution until Congress provides for its implementation. Stated otherwise, while the Constitution has recognized or granted that right, the people cannot exercise it if Congress, for whatever reason, does not provide for its implementation. Ruling on the second issue. Comelec Resolution No. 2300, insofar as it prescribes rules and regulations on the conduct of initiative on amendments to the Constitution, is void. It logically follows that the Comelec cannot validly promulgate rules and regulations to implement the exercise of the right of the people to directly propose amendments to the Constitution through the system of initiative. It does not have that power under RA number 6735. Reliance on the Comelec's power under Section 2 of Article 9C of the Constitution is misplaced, for the laws and regulations referred to therein are those promulgated by the Comelec under a. Section 3 of Article 9C of the Constitution, or b. a law where subordinate legislation is authorized and which satisfies the completeness and the sufficient standard tests. Ruling on the third issue. The foregoing considered, further discussion on the issue of whether the proposal to lift the term limits of the elected national and local officials is an amendment to, and not a revision of, the Constitution is rendered unnecessary, if not academic. Principles. Section 2 of Article 17 of the Constitution is not self-executory. Without implementing legislation, Section 2 cannot operate. Thus, although this mode of amending the Constitution is a mode of amendment which bypasses congressional action, in the last analysis, it still is dependent on congressional action.